Please be seated. Veuillez vous asseoir.
So next three sessions, in fact, are intended to provide defense with opportunity to present its closing statements. Before I give floor to Mr. Bougon. Mr. Bougon, one question: could you just provide us with some specification how many speakers will be present statements in which order?
Thank you, Mr. President. This is part of my presentation. There will be 2 speakers only.
All right. So then, Mr. Bougon, you have the floor.
Good morning, Mr. President. Good morning, Madame la Juge and Monsieur le Juge. 3 years later, I have the honor to address the trial chamber and to begin the presentation of Bosco Ntaganda's closing statement. Mr. President, it's been a long trial, and it's been a difficult trial. Number of witnesses have been heard, and numerous documents have been submitted in evidence. Yet, listening to the prosecutor, who unfortunately cannot be with us this morning with us, listening to the prosecution and the prosecution team closing statement yesterday, brought me back to September 2015. I respectfully submit, Mr. President, I could have sat before a TV screen, insert the video of the 2015 opening statement from the prosecution, press play, and the result would have been the same. With all due respect, the prosecution mistakenly takes its theory for reality. Prosecution takes the view that the theory of the case it presented in September 2015 has not been affected by the evidence heard during the last 3 years. Indeed, other than 4 isolated quotes from the evidence and sweeping statements which I respectfully submit are not very useful, we've heard the same as in 2015. Now, regarding the quotes referred to by the prosecution, quotes from selected witnesses, but these quotes are mentioned without providing any information on the context, without adding any information as to what these same witnesses said at other times, or whether what they said in cross-examination. Sweeping statements. Let me use one example. Mr. Ntaganda would like you to believe that all witnesses lied without explaining why or how. That's what we heard yesterday. Well, we say, Mr. President, that statements like this are not helpful because they do not represent what the defense has been doing over the last 3 years. For the audience, this might raise some questions as to what really happened in Ituri in 2002 and 2003. But for the professional judges of this chamber, respectfully, Mr. President, we say more was required. Now, regarding the witnesses who provided evidence, is it the case that many of them provided unreliable evidence or straightforward lies? The answer is yes. Openly, I can look at the trial chamber and say, yes, it is the case, without a doubt. Now, is the number of witnesses who provided false evidence an important consideration? No, it's not. It is not. What is important, and we are confident is what the chamber will do, is to look at the evidence, witness by witness, and assess, in light of the totality of the evidence, whether what they said can be relied upon or not. Where the defense takes the view that witnesses provided false or unreliable evidence, the defense closing brief and the defense reply provide details, not only why the information is unreliable, but also, in many cases, what the motivation of the witness was for doing so, even though this is not even a legal requirement. Significantly, however, other than for a few exceptions, such as P768, who, in our view, is a straightforward liar, and whose evidence cannot be relied upon in any way. Well, other than for these few exceptions, the defense highlighted, for the benefit of the chamber, which part of the testimony of witnesses is reliable and which part of the testimony of the same witnesses is either false or not reliable. Let me use a few examples. P17, P907, P901. By the way, P901 appears to have been kind of forgotten in the prosecution's presentation yesterday. But these are examples of the defense approach. And I'll come back to these witnesses later. Neither the prosecution nor the legal representative of victims were happy with the defense approach of, within the testimony of a witness, saying what can be relied upon and what cannot be relied upon. In their respective brief, they argue you can't have a witness and agree on some parts and disagree on the other. Well, that is wrong, Mr. President, and we have explained why in our briefs. Now, it is important to compare the defense submissions with prosecution arguments. According to the prosecution, all of its witnesses said nothing but the truth, and all of their evidence is reliable, period. I have yet to see or hear, Mr. President, any one observation, any note of caution expressed by the prosecution regarding a single of its witnesses. I respectfully use the word, Mr. President, dream world. In fact, we are confident that the trial chamber will come to the conclusion that numerous prosecution witnesses did provide unreliable evidence and draw the proper conclusions. All this to say, Mr. President, is that we're back to square one, 3 years later. I highlighted the fact 3 years ago that the defense and the prosecution were at cross purposes, had diametrically opposed theories that were entirely different. One presents night, the other presents day. Well, today, 3 years later, the situation has not changed. The chamber is still faced with two opposing theories based on the same evidence. Well, what we say, Mr. President, is that this evidence will allow the chamber to determine which of the two theories should be the basis for its judgment, and then to use the evidence, witness by witness, to determine the responsibility of Mr. Ntaganda. We also respectfully submit that the prosecution's theory, as presented in its brief and as presented yesterday, is based on the internet. We are mindful, Mr. President, that the reputation of Bosco Ntaganda in the internet is not the best. We believe, however, that this reputation on the internet is wrong. And we believe that based on the evidence, the real personality, actions, contributions, responsibility of Mr. Ntaganda will arise. Let us look, Mr. President, at one example, which is the prosecution's characterization or portrayal of Bosco Ntaganda himself through its brief and through its argument. Yesterday, we heard the prosecution say that Bosco Ntaganda was nicknamed the Terminator because he was a notorious violent killer. Over and above the fact that I can't recall where in the evidence this comes from, this is entirely wrong. A quick look at the evidence reveals just how and to what extent the prosecution's portrayal of Bosco Ntaganda is wrong. Let's take a look at a few of these arguments. Prosecution believes that Bosco Ntaganda interfered with witnesses. Well, I recall, Mr. President, and I wasn't going to raise this until the prosecutor raised it yesterday, but the prosecution gained access to every single one of Bosco Ntaganda's telephone conversation from the detention center before and during the trial. And yet, no charges were laid for any type of interference. The prosecution says that Bosco Ntaganda committed murder. Well, we say, Mr. President, that the evidence reveals that he did not commit murder. If we look, for example, because that's the only evidence that is charged, which is that of a priest named Abbé Buonalonga, the evidence reveals that he was not killed by Bosco Ntaganda. And the evidence provided by P768 in this regard is simply not true. Now, in terms of reputation, we might look at other issues. Like we go back to 2000. Did Bosco Ntaganda kill Nguene, the prosecutor, who had detained Kawa? Did Bosco Ntaganda kill César, the strongman of the APC at the time? No, the evidence reveals he did not. Did Bosco Ntaganda kill Claude, the strongman of Lompondo in 2002? No. The evidence reveals that Bosco Ntaganda did not kill these people. Rape. Prosecution would like to picture Bosco Ntaganda as a rapist, that he would have raped P10. Well, we'll address the evidence of P10 later, but we say that the record speaks for itself. Bosco Ntaganda did not commit rape. Quite to the contrary, the evidence reveals what is Bosco Ntaganda's position regarding any type of sexual violence within his ranks, and what he said to his troops about rape, and the actions he took in that regard. The prosecution would like to picture Bosco Ntaganda as someone who committed pillage. Well, I refer you, Mr. President, to the evidence of P901. This was really an absurdity, the way it was portrayed. And the Chamber will recall at the end of the cross-examination how P901 reacted to these questions. As of allegations of pillage at the hospital. Chamber will recall the testimony of P768, which is linked to those anti-personnel landmines that would have been used. That's not true. The evidence establishes that there was no pillage. The prosecution would like to say that Bosco Ntaganda set a negative example. Well, when we look at the example set by Bosco Ntaganda, we come back to 901, who says he's the most respected individual in the FPLC. So was he the most respected individual because he set a wrong example? We say, Mr. President, the two don't go together. And that comes from a prosecution witness. We also recalled the evidence regarding the adoption of the ideology of the FPLC, to which Mr. Ntaganda contributed. Prosecution would like to say that Bosco Ntaganda was not credible. Well, Mr. Ntaganda testified for 127 hours. He answered all questions, regardless of whether the questions were sensitive or not. He provided straightforward answers to every question put to him regarding his acts and conduct. Prosecution would like to say that Bosco Ntaganda failed to take measures to prevent or punish. Again, the record is replete with examples of measures taken by Bosco Ntaganda. Even the prosecution yesterday, they pleaded to this chamber. The prosecution recognizes that other than for the crimes charged, Bosco Ntaganda took all kinds of preventive measures and repressive measures. The prosecution would like to say that Bosco Ntaganda possessed a specific intent to discriminate against non-EMA civilians. We'll get back to this example, but Mr. President, the issue of what happened in Mandro in the spring of 2002, where a number of Lendu civilians who were targeted by their own because they refused to attack EMA civilians, showed up in Mandro, and they took refuge there, and they were protected. They were welcomed by Chef Kawa, and they were protected. Prosecution would like you to believe that the witness D54, who was not cross-examined, is a witness who mentioned Bosco, but she wasn't talking about Bosco Ntaganda. Need I say more? Mr. President, what this case is about is the following, and this is what we will address. This case is about Bosco Ntaganda. And we see from the few examples I just raised that Bosco Ntaganda is not the man that we have been hearing about for the past day and a few hours. This case is about UPCRP, Union des Patriotes Congolais, Réconciliation et Paix. This case is about the FPLC. It's about an alleged common plan to house non-EMA civilians. It's about 2 attacks and alleged enlistment of and use of soldiers who would have been aged below 15. This case, Mr. President, is about the charges which are in the UDCC, the updated document containing the charges, as confirmed. Not more. My colleague will say further about this. Our presentation, Mr. President, today will be divided into a number of parts. Some will be longer than others. Some will be quite short. But we will address Bosco Ntaganda based on the evidence, not on the internet. We will address for the chamber defining moments in the procedure and determining factual issues that will impact what the chamber and how the chamber can assess the evidence. We'll address the contextual elements of Article 7, crimes against humanity, and I stand to be corrected, but we haven't heard anything about crimes against humanity yesterday. And we'll address, of course, the law applicable to the common plan. We will look at Mr. Ntaganda's evidence regarding alleged soldiers aged below 15. More importantly, we will look at witness credibility issues, and we will look at Bosco Ntaganda's responsibility. And at the end, we will look at command responsibility issues rather quickly. Allow me to begin immediately with the first part, dealing with Bosco Ntaganda himself. Bosco Ntaganda based on the evidence. These are the issues we will address: his personal background, his testimony, the prosecution's cross-examination, corroboration of his testimony, and we will suggest to this chamber what criteria to use in order to assess and accord full probative value to his testimony. His personal background is important to assess the charges. The fact that he joined the military in 1991 at the age of 18, that his family was a victim of the Rwanda genocide, that Bosco Ntaganda contributed to fighting the Rwanda genocide. Bosco Ntaganda's background as an instructor. That was his main purpose, his main qualification in the military. How Bosco Ntaganda ended up to join RCD-KML. And then he became Wamba Jawamba PPU commander, due to his quality and his courage as a fighter. It is interesting, Mr. President, that RCD-KML, as the evidence has shown, was sponsored by Uganda, as opposed to RCD-Goma, who was, at that time, sponsored by Rwanda. There were no close ties between Rwanda and Bosco Ntaganda, contrary to what the prosecution would like you to believe. When Bosco Ntaganda came to Bunia in 2000, it was the first time he set foot there. He did not know Bunia, and he was a member of the APC. Bosco Ntaganda testified why he became a mutineer from the APC, because the APC had lost its bearing already in 2000. And he created the Shui Mobile Force. We even heard yesterday that the Shui Mobile Force included soldiers or members who would have been aged below 15. I don't think there is any evidence on the record to that effect. Now, what was Bosco Ntaganda's role in these events? That's important. Bosco Ntaganda is an important character. Of course, we would not be here if he was not an important character. Did he have influence on the members of FPLC? Yes, he did. He was one of the main characters of FPLC. Mr. Ntaganda did not hide this. He highlighted the fact that he tried as best as he could at all times to ensure that FPLC would conduct its operations in accordance with his military ethos. Bosco Ntaganda was highly respected. He contributed to the adoption of the FPLC ideology. It is in our brief. I need not go through all the steps. Bosco Ntaganda was animated. He was a soldier, animated by his desire to create a disciplined army. Bosco Ntaganda said that when it was mentioned, nos enfants, in the logbook, he explained that the army is a family. He was one of the important members of the family. But the children in the family, that doesn't mean that they are children. They are the members of the army. and military commanders take care of their children. They take care of all of their children. That's what we find in the logbook. Bosco Ntaganda was recognized as a courageous and as a qualified and effective tactician and fighter. When Bosco Ntaganda responded to questions of the prosecution, says, "I will admit I was a tactician." That doesn't say anything else than "I was a tactician." And we should not read more into these words than what is there. Bosco Ntaganda was a staff officer and not a commander. He did command. He did exercise command at times in certain operations. When, Mr. President, the questions was put to him, what difference does it make that you are in command of Mangualu? Well, Mr. Ntaganda responded, it makes all the difference in the world because I'm in command. And at that point in time, I exercise command. That is different. But at other times, he was not in command. He was a staff officer. We have organizational charts that were admitted in evidence on which Mr. Ntaganda was not cross-examined, which show the relationship between him and Kisembo. When Mr. Ntaganda issued orders, it was pour ordre on behalf of Kisembo. But we'll address that later. He was a loyal officer. When Mr. Lubanga asked him, do not fire on the Lendus so that they can attend the meeting in December in Arua, he abided and issued orders not to fire the Lendus. When Kisembo left the movement to create his own UPCK, Mr. Ntaganda remained loyal to Lubanga. Mr. Ntaganda was not a politician, and that's very important. Mr. Ntaganda was a soldier, a tactician. He contributed to the FPLC, and in the overall scheme of things, he was a minor player in all the situation as it unfolded. What is more important, Mr. President, is that Bosco Ntaganda's involvement in these events resulted in lesser number of victims rather than more. When he showed up in 2000, when he came back in 2002 and organized the troops, because it was in self-defense, because civilians were being targeted by Lendu combatants and the APC, he organized them so that the fighting could take place military on military, not with civilians, not on the civilians. Moving on to Bosco Ntaganda's testimony. We say it is certainly the most important aspect in this trial. And we invite the chamber, as did the prosecution yesterday, to scrutinize Mr. Ntaganda's testimony. One caveat in terms of his testimony, there were a number of interpretation issues, and we invite the chamber to be careful with respect to the words used, because there were differences between the French and the English, and there were differences between the Swahili, the language used by Bosco Ntaganda, and the transcript. I said he testified for 127 hours, calmly responded to all questions put to him, candidly responded to sensitive questions, did not try to evade his responsibility, whether it was questions related to César, to Patrick, who was killed when he tried to assassinate Mr. Ntaganda in 2000, Nguene, Claude, Buonalanga, whether soldiers, what was his own test for soldiers in terms of who he would recruit and who he would not recruit. When the prosecution came up with a document he had not seen, which was one of his agenda. He immediately clarified, says, "Yep, I stand to be corrected. That's the date, that's the correct date." When Mr. Ntaganda traveled to Aru, prosecution would like you to believe that he traveled to Aru because he was there to order the operation on Mongwalu. Mr. President, Bosco Ntaganda, straightforward and very openly, he said, "I went to Aru. We did provide weapons to Jérôme. We did provide uniforms to Jérôme. I did go and speak to the troops of Jérôme. Jérôme was involved in fighting activities with APC troops coming from Mongwalu. But I commanded the operation which is subject to the charges." Need I say more? Bosco Ntaganda in cross-examination, which is quite significant. Let me go back again to his testimony. Mr. Ntaganda, during his testimony at all times, responded to where he was, what he did, and why he did it. Now the chamber must assess. In cross-examination, 56 hours of cross-examination. The cross-examination was split in two parts. Admittedly, Mr. President, for us, this was the worst scenario. And it was not very openly that we conceded to this scenario. My instructions were clear. Bosco Ntaganda said, "I want to say it all, regardless of the timing considerations and when the cross-examination takes place. I want to tell my story." And he did. And what he said, Mr. President, is relevant to the charges, as opposed to what some legal representatives said this morning. Cross-examination with 1 month to prepare in the middle. Yet, the prosecution opted not to challenge Bosco Ntaganda on significant portions of his testimony. Then the prosecution says in his brief, well, there's no legal duty or legal obligation to put questions on everything the accused testifies about. Well, in part, they are right. There's no obligation. But when the accused is going to testify about a material and important aspect of the prosecution's case, responding directly to prosecution allegations, and then the prosecution decides not to cross-examine, well, the chamber is bound to take that into account when assessing the testimony. Corroboration of Mr. Ntaganda's testimony. Both the legal representative and the prosecution say that Bosco Ntaganda's testimony was not corroborated. Well, that is incorrect, Mr. President. The main source, of course, is the Ntaganda logbooks, which do corroborate Mr. Ntaganda's testimony to a large extent. However, there's more. Defense witnesses. Now, it has been said that because Mr. Ntaganda testified early, that the defense witness should not be believed because they knew Bosco Ntaganda's testimony. I would not surprise anyone by saying that had Mr. Ntaganda decided to testify last, then we would have heard today, well, because he testified last, it must be that it is because he heard his own witnesses. That is, in our view, Mr. President, for the chamber to assess, but it is incorrect to say that the testimony of defense witnesses was impacted or influenced in any way by the accused's testimony. And it's certainly not established on the record that there was any knowledge of the accused's testimony with these witnesses, such as 251 and witness 243 and witness D17 and witness D54. Well, D54 testified prior to. A lot of documentary evidence was used during Bosco Ntaganda's testimony, which corroborates his testimony. The Chamber knows that we we would like the Chamber to attribute very little probative value to United Nations document. What they are good for is for the purpose we use them during Bosco Ntaganda's testimony. Because when Mr. Ntaganda describes an event, when that event is mentioned in a document, it corroborates the event. Might not corroborate the detail, but it corroborates the event. More than that, very little weight can be attributed to these United Nations or MONUC document. The evidence provided by prosecution witnesses is significant in terms of corroborating Mr. Ntaganda's testimony. Sudden recollection of memory by P55, which we will address later, are significant in this regard, as well as P17. Now, P17 is the only witness we have on the record who provided information regarding the beginning of the second FPLC attempt to liberate Mongwalu. And in this part of his testimony, he corroborates Mr. Ntaganda. He said Mr. Ntaganda was not there. He showed up in Mongwalu after the fighting in Mongwalu had stopped. Mr. Ntaganda's testimony must be accorded full probative value. Mr. Ntaganda decided to testify even though the prosecution had every one of his telephone conversations. He decided to testify despite all the material on the internet that was available to the prosecution. He decided to testify despite 10 years or more of investigation by the prosecution. He decided to testify because he wanted to tell his story. The proper criteria, in our view, to address the testimony and the weight to be attributed to the testimony can be found in a Supreme Court of Canada decision in 1991, which is the Queen versus WD. That related, of course, to a trial before jury. But in that decision, the Supreme Court said these are instructions which should be given to the jury because that's the way to assess the testimony. If you believe the evidence of the accused, obviously you must acquit. If you do not believe the testimony of the accused, but you are left in reasonable doubt by it, you must acquit. And even if you are not left in doubt by the evidence of the accused, you must ask yourself whether on the basis of the evidence which you do accept, you are convinced beyond reasonable doubt by that evidence. Moving on to the second part, defining moments in the procedure. There are a few. I did not anticipate addressing these issues, but the issue of restrictions imposed on Bosco Ntaganda deserve a word. The issue is not the decisions rendered by the Chamber in the course of trial. Now is not the time to address such issues. The issue of related to the restrictions is simply that the allegations of interference, which were submitted by the prosecution, for some reason, come from the same insider witnesses whom we say provided unreliable evidence. It is a factor to bear in mind. The second issue, of course, is the prosecution knew more than the defense when the defense was cross-examining prosecution witnesses. But the most important aspect of this issue is the use by the prosecution of Bosco Ntaganda's telephone conversations. Prosecution was authorized to use a number of conversations, and their strategy backfired. How did it backfire? Because the conversations that were used during Bosco Ntaganda's testimony highlight the fact that Bosco Ntaganda, very shortly after arriving in The Hague, 5 April 2003, Bosco Ntaganda was discussing with Rafiki their trip to Mongwalu using Rafiki's vehicle. That's the trip that was before the trip to Rwanda. Bosco Ntaganda was discussing with Peter, his personal secretary, the event about the execution at Ndromo involving theft at the house of a Nande family. Bosco Ntaganda was discussing the trips he took to Goma with Peter in September 2013, way before any hearing on the confirmation of charges. Peter acknowledged in these conversations going to Aru with Bosco Ntaganda. What we can see from these conversations, they are not straightforward evidence, but they do support and corroborate issues testified about by Mr. Ntaganda. I won't linger long on the disclosure of evidence issue, but one issue will be mentioned later on during these submissions regarding the identity of persons interviewed by P46, which is an issue that we just managed to confirm recently, and that deserves some submissions. I move on to the evidence that was neither adduced nor called by the prosecution. Now, that's an interesting one. And I'll refer to one example, which is, in our view, very important. It is the fact that many aspects of the evidence adduced by the prosecution call upon military knowledge, which we respectfully submit goes beyond the normal knowledge of judges. The range of weapons, the use of certain weapons, the workings of an état-major, the relationship between chef d'état-major général and his two chefs d'état-major général adjoints. What is the difference between a staff and line relationship? Whether an operation can be undertaken by an officer in a certain area without seeking permission of the higher chain of command. Preparations for an attack. All of these issues require military knowledge for which the prosecution omitted to call a military expert. Let me use one example again, referring to the first attack. Prosecution cross-examined Mr. Ntaganda, but argues that 2 brigades were involved and that it is not normal that Bosco Ntaganda, as the overall commander of the operation, was not there with them. Well, had a military expert testified, and it was the duty of the prosecution to put that knowledge before the chamber, then it would understand that what Mr. Ntaganda testified is the proper way it is done. In respect of military issues, clearly explained by Mr. Ntaganda, and where no expert knowledge was adduced, we say that not only the benefit of the doubt must go in favor of the accused, but the chamber must not look further than the testimony of the accused, who is a military expert. I move, Mr. President, to determining factual issues in the case. What are these determining issues? Well, they are issues that arose during the trial, mostly factual, which impact the assessment of the evidence as a whole in favor of Mr. Ntaganda. Issues which constitute a turning point regarding the overall responsibility of Mr. Ntaganda. So let us look, Mr. President, together at some of these issues. First one, Lendu civilians targeted by Lendu combatants took refuge in Mandro, where they were protected by Chef Kawa and Bosco Ntaganda. I've already mentioned this event earlier, and the fact that the prosecution did not cross-examine D54. Why is it important? Well, because it shows the attitude of UPC and APC mutineers, because FPLC did not exist at the time. It shows the attitude of Bosco Ntaganda regarding the civilian population, even before the creation of UPC, Réconciliation et Paix, and FPLC. It shows proactive measures taken to protect non-IMA civilians. It is determining, Mr. President, because it confirms the absence of a policy to attack civilians. It also confirms that there was no Article 7 attack. It also confirms that UPC-RP and FPLC did not discriminate against civilians, let alone non-IMA civilians. And it also shows that Bosco Ntaganda did not harbor the specific intent to discriminate. Bosco Ntaganda's logbooks. Well, first, there are prosecution exhibits. We have the numbers on this slide, which is on the screen. Prosecution has said and repeated yesterday that the logbook contains contemporaneous internal records of the UPC's military activities on a near daily basis from 19 November 2002 until 22nd of February 2003. Before I comment on this Ntaganda logbook, one issue which was mentioned is we find in the prosecution brief, and I think in the submissions yesterday, about the short Ntaganda logbook. Prosecution submits that the short Ntaganda logbook, the applicable dates was October 2002 until 2 June 2003. Well, that's not what the evidence says, Mr. President, and I stand to be corrected, but I don't know where these dates come from. The dates are on the record. Now, Bosco Ntaganda's logbook, they represent the actual words pronounced by main characters, including Bosco Ntaganda. These were accessible only to a few FPLC members. They are contemporaneous evidence. More importantly, they are considered, or they were considered as confidential documents not accessible to the enemy. They are a reliable representation of FPLC modus operandi. We invite the trial chamber to carefully scrutinize the logbook, which will determine that it does not show anywhere either a policy to attack civilians, either attacks on civilians, or any type of crimes being committed by FPLC. Now, that's a long period, Mr. President, from 19 November until 22 February. Why would the actions of the FPLC be different before or after? When we look at this, we see the true nature and character of the FPLC. we see how they were conducting their business. That's important. It is determining because when Bosco Ntaganda commented on the messages, it allows the trial chamber to have very useful inside information. It's also very useful to assess witness testimony. We find in the logbook messages authored by P768 about measures taken to discipline, actually to execute a member of the FPLC for killing a Lendu civilian, and yet it was denied by the witness. It confirms the absence of attacks against pursuant to Article 8, which is war crimes. And it confirms all the measures taken to prevent or punish. Next issue is the range of FPLC VHF radio communications. There are two types. Communications between two handheld VHF portable radio and communications involving one VHF radio and using the base, which the chamber will recall was a device much more powerful than a handheld radio VHF, and the fact that what frequencies were used and the inability to communicate between certain areas. It is clearly established in the evidence, Mr. President, that from Bunia, it was not possible to use a VHF radio to communicate with operations conducted away from Bunia, either because of the frequency used, but more importantly, about the capacity or the range of these communications. It is important because it allows the chamber to know what was possible and what was not, and to assess the relevant testimony. Where P17 testifies about alleged conversations between Kisembo, who was in Mongwalu, or he could have been in Kilo, along with Salumu, who would have been in Kobu. Well, we know, Mr. President, that these type of conversations are not possible. If they are not possible, it is determining to assess why did P17 adduce such evidence. Measures taken by Bosco Ntaganda in Comanda. This is immediately after the departure of Lopondo, before the creation of FPLC. Operation in Comanda. We have a witness who described this operation during which no crimes were committed and civilians had left. Yet, some members started to loot. As soon as Mr. Ntaganda got the information, he immediately reacted, ordered for the items to be looted, and publicly punish those soldiers responsible. Now, that is not benign action by Mr. Ntaganda. This sends a strong message. And everyone who were there present during this operation would remember clearly Mr. Ntaganda's position regarding looting. Why is it important? Because it was the message. It illustrates that FPLC ideology was not theory, it was in practice. It is determining because it confirms measures taken. It confirms the will and the attempt to create a disciplined force. And it confirms that Bosco Ntaganda did not harbor the mens rea for pillage. Next issue. The first execution of an FPLC member by firing squad. Mr. President, the ultimate punishment which can be imposed in any army. It's a form of punishment found in the military codes of many states. It was, until very recently, still in the Canadian Military Code of Justice. No longer there anymore, but it was. Then the civilians were victims of looting. An investigation immediately conducted by Bosco Ntaganda. A punishment approved by the Commander-in-Chief. It is the most powerful and effective form of deterrence. Is it foolproof? No, it's not. But you cannot go further than that in terms of deterrence. The prosecution would like to use this example to show that Mr. Ntaganda was trigger happy, that he shot everyone left and center. That's not what the evidence reveals. The evidence reveals that Mr. Ntaganda took this measure, investigated this case in accordance with his own military ethos. When Mr. Ntaganda testified, he confirmed that the person executed, the FPLC member executed, happened to be P16's brother, which might explain and provide reasons as to testimony or evidence provided by P16. This first execution is important and it is determining because it shows the absence of discrimination against civilians. The victims were Nande. It confirms the absence of a policy to attack civilians. It confirms no Article 7 attack. And it confirms that Bosco Ntaganda did not harbor either the mens rea for pillage or the specific intent to discriminate. Next determining factual issue, Mandro video. Military parade, a gathering of FPLC members who were trained in Mandro. We have soldiers on that video who came from Aru, Jérôme's forces, who were not Emma and who were not of the Emma ethnic group. The gathering takes place shortly before Bosco Ntaganda's mission to Aru. And it takes place before the soldiers trained in Mandro were organized into a formal brigade, the command of which was entrusted to Salomo. The Chef Kawa's speech is a powerful one. It is direct instructions given by the political, the executive, to its armed branch or to its military arm. It is in evidence in the speech record that Bosco Ntaganda contributed to the speech. Soldiers were informed about the objectives of UPCRP and policy. Now, it is important because the soldiers that you see on this video, proudly wearing their new uniforms, proudly showing their weapons and explaining how their weapons work to Chef Kawa, are the same soldiers who took part in the first attack as charged, the operation in Mongwalu. FPLC ideology was addressed, discipline was addressed, protection of civilians were addressed, lack of discrimination was addressed. It is determining because it confirms the multi-ethnic composition of the brigade which went to Mongwalu, because the instructions were given to those who took part in that operation. No policy to attack civilians. This is straightforward evidence of an absence of a policy to attack civilians, let alone non-EMA civilians. Now, the prosecution here, I referred earlier on to where the prosecution had, in our view, a duty to call witness, because the prosecution argues that this Mandro is propaganda. And I'll address the issue of propaganda later. But at a minimum, if someone is to argue that it was propaganda, it would be nice to have one witness who was present who would say, oh, this was a fix. I referred to the words of the prosecution yesterday. Why else would one reporter be present if it wasn't for propaganda? Mr. President, where is the evidence that what was mentioned in that speech is not true? Where is the evidence that this speech was not delivered openly and with a purpose to FPLC troops? Next determining factual issue. The second execution of an FPLC member by firing squad. Again, ultimate form of punishment which can be imposed. Early January 2003, a Lendu civilian victim of murder by an FPLC commander called Liripa. An investigation is conducted within 401 Brigade and within the Southeast Operational Sector. It involves the commander of the 401 Brigade, and it involves the commander of the Southeast Operational Sector. This investigation is referred to in the Ntaganda logbook. The execution takes place in public. A report, procès verbal of the execution, is drawn up to be sent to higher headquarters. That's in the logbook also. Again, the prosecution's attempt to use this incident to say that members of FPLC were trigger happy simply is not what the evidence reveals. This issue is determining because, again, it shows a lack of discrimination. It shows what was happening in Mongwalu in January 2003. It confirms that when members of FPLC did commit breaches or when there were problems, they were reported in the logbook. And the logbook begins as early as 19 November. That allows the trial chamber to determine what was the real situation. These messages are referred to in the defense closing brief. All these messages issued by commander of 401 Brigade, where it reports on the situation, on patrols being out there, looking at what's happening, on the situation being calm. It's all there. And that's important, Mr. President, to assess what was the situation. And it also determining to assess credibility of insider witnesses such as P768. Next determining issue. P290 traveled to Mongwalu with Bosco Ntaganda, as established in the evidence. This, Mr. President, is sorry. It established that P290 did travel with Bosco Ntaganda to Mongwalu. It is explained in detail, first in the defense closing brief, and then in the defense reply to responding to prosecution arguments. It is directly related to evidence regarding the first attack as charged. It is directly related to Bosco Ntaganda's testimony. And it is determining because it does corroborate Bosco Ntaganda's testimony. Now, the prosecution argues at one point, we did not know that Bosco Ntaganda would testify that he traveled to Mongwalu with P290. That's really amazing, Mr. President. P290 is a prosecution witness. Need I say more? Next determining issue. Bosco Ntaganda reached Mongwalu by foot. That's what the evidence establishes. P17 also reached Mongwalu on foot. And the evidence establishes, both on maps and the testimony of Mr. Ntaganda, that it was not possible to use a vehicle between Dala and Mongwalu. Why is it important? Because it establishes that during the operation in Mongwalu, there were no vehicles that could reach Mongwalu. And there were no vehicles there other than those seen in the Mongwalu video. It is determining because it contradicts the unreliable evidence provided by insider witnesses, as well as even by other prosecution witnesses. That's in our defense closing brief. But that's not what the video shows. There is no structural damage. And it's also very important because when you look at houses on the video with corrugated iron roofs, the roofs are still there. So why is it that the FPLC would go to Mongwalu and leave those corrugated iron roofs, but take all those away in Sayo? Asking the question provides the answer. They didn't. It shows also that the absence of vehicles in Mongwalu. It shows that the usine was destroyed long before these events. It shows that the civilian population is returning to Mongwalu. It shows that the atmosphere is peaceful. It shows the attitude of Kisembo, of the FPLC, of the UPCRP, and of Bosco Ntaganda regarding civilians, non-EMA civilians. It displays the willingness for the FPLC for all civilians to return. That's an important consideration which defeats numerous prosecution arguments. Not only does the Mongwalu video corroborate the testimony of Bosco Ntaganda, it contradicts the non-reliable testimony provided by insider witnesses. Confirms that there was no policy to attack civilians pursuant to Article 7. No Article 7 attack. No discrimination against civilians, let alone non-EMA civilians. No specific intent to discriminate against non-EMA civilians. And it also confirms, very significantly, that this operation in Mongwalu did not reach Nzibi. Anything that the trial chamber has heard about Nzibi was placed on the record by P768, simply not part of the operation. We can see that on the video. Nzibi is not there. It was made up. Next determining factual issue. December meeting held in Arua. Completely different issue. But I tried to move in a chronological pattern. This meeting was initiated by Uganda. The aim was to sign an agreement between Uganda and UPCRP. Voluntary participation from UPCRP. The delegation of UPCRP is headed by a non-EMA, Jalum Jekoni, who was one of the main, if not the main, secrétaire national. At the meeting, the delegation is ambushed by Uganda delegation, and we learn that two political parties created in Uganda are to be included in this agreement. The UPCRP delegation refused to sign. I said earlier, the FNE Lendu delegation, well, I shouldn't say FNE because it didn't exist at the time yet, but the Lendu delegation were able to attend this meeting only as a result of Bosco Ntaganda ordering 505 Brigade not to target the plane. Yet, as the meeting was taking place, we hear from Thomas Lubanga that UPDF are bombing FPLC units in Ndrili. This marks a turning point, Mr. President, between Uganda and UPDF and UPCRP. It illustrates a willingness of UPCRP to negotiate, to enter into an agreement with Uganda. It issues respect for orders issued by President Lubanga. It marks the event or the beginning of events leading to the 6 March 2003 conflict in Bunia, which has nothing to do but civilians. It is a straight political power conflict, with UPDF from that point on becoming de facto an enemy of UPCRP. It confirms the double play of the UPDF, pretending to be helping the civilians around, in and around Bunia, and yet attacking civilian positions close to Ndrili. Confirms absence of policy to attack civilians, absence of Article 7 attack, absence of discrimination against civilians. It paved the way, this agreement, to FNI attacks against civilians. Next issue. Lubanga's plan to cooperate with the FNE to ensure the departure of UPDF. Mr. President, from that point on, the conflict takes a completely different picture. You have UPDF, you have APC, you have Lendu combatants, and you have the central government, all of which are taking measure. Why? Because they see that the UPC is effective and is about to really solve the problem and solve the issues in Ituri. And there's a plan to provide weapons to Ugandan rebels. Mr. Ntaganda testified, the enemies of your, the friends of your enemy are your enemy, or something like that, but we know what he meant. That's why weapons were provided. Few people were informed, some of whom were informed but did not acknowledge when testifying. Now, this plan to ensure the departure of UPDF shows that Lubanga is willing to reach an agreement and to work with the Lendu combatants because his priority is Ituri. It has nothing to do with Lendus or chasing Nonema. It has to do with ensuring that UPDF, which has created problems, which wants to hang on to its position in Ituri, is the problem. And UPDF has to go. There are agreements and evidence which say that UPDF was supposed to go, but it was refusing to go. But when Museveni from Uganda learned about this, he bombed Pandroma. This plan to cooperate with the FNI to ensure the departure of UPDF, it confirms that there were no policy to attack civilians. There was no Article 7 attack. There was no discrimination against non-EMA civilians. Bosco Ntaganda was sent to deliver weapons himself, to negotiate face-to-face with Lendu combatants. He did so. He did deliver the weapons in Libya. Is that someone who harbors a discriminatory intent? Not at all, Mr. President. Next issue. Witness P55, described yesterday as a senior military insider, had a conversation over the Turaya with Bosco Ntaganda on the 2nd of March 2003. Mr. Ntaganda testified he was in Maagi at the time, which was confirmed by P55. P55 was in Bunia along with Kisembo and Rafiki. And the purpose of the conversation are corroborated by United Nations or MONUC documents. It is important because that conversation was not mentioned during the examination in chief of P55. He suddenly recollected this conversation. Why? Because he knew very well, Mr. President, he knew that Bosco Ntaganda was aware of that conversation. And he recollected the conversation, which establishes where Mr. Ntaganda was at the time, and it establishes that Kisembo returned to Bunia before Mr. Ntaganda did. It establishes that this senior military insider did not speak to Bosco Ntaganda from the time Mr. Ntaganda left to Maagi until he returned to Bunia. It allows to assess the credibility and the reliability of evidence, and it corroborates Mr. Ntaganda's testimony. In fact, Mr. President, I will go as far as say that this conversation deconstructs, if it's the right English word, I'm not sure, I was looking in the dictionary yesterday, P55's testimony regarding the events which took place during the second attack as charged. Next determining issue is that of the absence of knowledge by MONUC representatives and NGOs to a certain extent. They did not have any information in February or early March 2003 regarding alleged crimes committed in Kubu. That's all explained in the defense closing brief. The prosecution's suggestion that MONUC learned of these events or of these crimes from Lubanga during a meeting which is recorded in a video simply does not walk. Why is it important? Because it is directly related to the testimony of P55. Directly related to allegations that everyone, quote unquote, knew about crimes allegedly committed in Kubu. That wasn't the case at all. It is determining because it contradicts P55. It confirmed that he fabricated his evidence in this regard. It corroborates Mr. Ntaganda's testimony, and it demonstrates that the prosecution's theory regarding general knowledge of crimes allegedly committed in Kubu is either false entirely or not supported by the evidence. Last determining factual issue, very shortly. I think my colleague will address that in more detail. It is significant, regardless of the fact that 283 persons were authorized to participate as victims in this case, as being alleged child soldier. The fact of the matter remains that the prosecution attempted to call 5 of these witnesses, and in the 5 cases, the evidence shows that they were not child soldiers at the time. And that should be the best that there was available. But my colleague will say more on that. Mr. President, there are a number of other such determining issues. Events related to César, to Nguene, to Claude, to the ousting of Lepondo by UPDF, to the fact that Bosco Ntaganda did not kill Abe Buonalonga, to the fact that Bosco Ntaganda did travel to Rwanda from 14 to 17 February, that Bosco Ntaganda did deliver weapons to FNE Lendu combatants in Libya, to the fact that Bosco Ntaganda was on mission in the Mahagi area from 21 February until the 3rd of March, that Bosco Ntaganda did fight APC, Lendus, and UPDF forces together in Mandro on 4 March all day long, that Bosco Ntaganda was in command of the FPLC operations in Mongwalu in June 2003, during which no crimes were committed. All of these are determining issues, but I will move on to the next part of our presentation, which is the contextual elements of Article 7. We haven't heard yesterday, I said that already, about crimes against humanity and the elements. There are 3 elements pursuant to Article 7. A widespread or systematic attack directed at any civilian population and pursuant to or in furtherance of a state or organizational policy to commit such attack. The existence of an organizational policy is an essential contextual element. Thus, in the absence of an organizational policy, there cannot be a crime against humanity. The case for the defense, elaborated in detail in our closing brief, is that neither the UPCRP nor the FPLC had or acted pursuant to or in furtherance of an organizational policy to commit attack against any civilian population. Mr. President, I'd like to recall in this regard the confirmation decision in Mbarushimana. It is an interesting decision. When you read this decision, the conclusion was, even though we can see that there were some Article 8 attack, we come to the conclusion that there were no policy to commit attack directed against any civilian population, and therefore Mr. Mbarushimana will not be tried before this court. Policy is much bigger, much more important than what the prosecution. Policy is, that's your raison d'être. That's what you do in life. That's what you want. That is your objective. That's not what the evidence reveals. Neither for UPCRP, neither for, and also for FPLC. Article 7.1 says, pursuant to Article 7, however, it is in the text of the essential element, a policy to commit such attack requires that the organization actively promote or encourage such an attack. This is not what the evidence reveals, quite to the contrary. Now, not only is the policy important for crime against humanity, it is also important with respect to the common plan. Common plan is a different concept. But if you don't have the policy to commit attack directed against any civilian population, then you cannot have a common plan as alleged by the prosecution. Again, I refer the chamber to the Mbarushimana confirmation decision. They said because we can't find the policy to launch attacks directed at any civilian population, we cannot find the common plan alleged by the prosecution. Now, what is interesting, that this is a decision at confirmation stage. The standard at that time is substantial grounds to believe. The chamber could not even find substantial grounds to believe that there was such a policy. We are at trial. This is beyond reasonable doubt. And when you compare the evidence in both cases, it would be clear-cut that the decision must show that there was no such policy. Now, looking at the policy, since the beginning of this case, there's one comment we might, that is necessary. And that is the fact that the prosecution and the pretrial chamber did the same. They said UPC, UPCRP, FPLC, put that all in one bag and that's the same bag. That's not correct, Mr. President. UPC was a political movement created in 2000. UPCRP is the de facto political government or political leader of Bunia starting in September 2002, and FPLC is the official or created military arm of FPLC. And it is important because in order to see whether there was a policy to attack any civilians, it's necessary to look at one common theme, and we need to look at the evidence separately to come up with the answer, and that is the prosecution allegations of propaganda. I mentioned that earlier. That's a common theme, and it was mentioned on a number of occasions yesterday. Well, that's not new. We see that all the time. On the one hand, evidence of UPC, RP, FPLC, information, or actions which go contrary to the prosecution's theory is automatically labeled as propaganda. And the prosecution argues that it is deserving of no weight. On the other hand, evidence of UPC-RP information or actions which tends to support the prosecution's theory, well, that must be true, Mr. President, and this must be deserving of probative value. Mr. President, such an approach is neither credible nor worthy of much consideration, in particular in the course of a criminal trial. Propaganda. What is propaganda? The spreading of ideas or rumor for the purpose of helping or injuring an institution, a cause, or a person. That's the Webster definition. This definition calls for the following elements: the spreading of ideas for a purpose and information which is false. Unless the prosecution has proved these elements, its propaganda arguments must be disregarded. How do we prove these elements? Does the information or the action really exist? Is it proved? What evidence is there that the information was not true? Witness, documents? Is there any evidence that the information was created for the purpose of achieving an objective? Is there any evidence that the information was disseminated? That we tried to use the information, or it was publicized by the organization? Not only do we not know, for example, using the Mandro video, whether this video was used, whether there's any falsity to the information in the video, we have no idea, no information, no evidence that this video was used with anyone. Why was that information not publicized to Monique or to others? Because it wasn't made for propaganda purposes. Mr. President, let me use one example, and I'm about to close on my time for this morning. An example of prosecution arguments for propaganda, which must fail. pacification efforts of UPCRP FPLC. Now, these efforts are expressly mentioned in documents. UPCRP assigns or appoints non-EMA secrétaire national to head the pacification project. There's a program document created. It's all in evidence. Numerous persons are selected and appointed to be members of the Commission de Vérité, Paix et Réconciliation at all levels. These members are appointed locally, not by UPCRP, but they are selected by their own communities. That's in evidence. Various CVPR, Commission Vérité, Paix, Réconciliation, travel across Ituri. A report and reports of activities of CVPR are produced. The Commission Vérité, Paix, Réconciliation is inaugurated in public in the presence of members of all communities. An official UPCRP delegation headed by non-EMA secrétaires nationaux negotiates with Lendu chiefs in Gongo under the guidance of Thomas Lubanga. Following these negotiations, concrete actions are taken. A secondary road is opened between Lipri and Bunia, allowing free access for all. When an FPLC officer is involved in unauthorized fighting in the area of Lipri, he's arrested and he's detained. More importantly, the ultimate achievement of UPCRP, a peace agreement is signed in Yaoundé involving all communities, with the exception of 2 members of a 5-member delegation. All others signed. The purpose was achieved. The strategic objective of UPCRP was achieved. A press conference is held, and Mr. Lubanga talks about this peace initiative, talks about this peace agreement. That's not propaganda, Mr. President. This is an example of UPCRP FPLC having concrete objectives, taking action to address these objectives, achieving concrete results, and informing the population of the true and concrete results achieved. Prosecution's propaganda argument related to UPCRP pacification efforts must be disregarded entirely. The same type of argument or analysis can apply to many other arguments by the prosecution. Now, before we end, I think we have a few minutes. I'll just say, in order to look at whether there was a policy, we need to look at a number of things. We need to look at the events, in which chronology the events took place, and we need to look at the UPC, documents, speeches, objectives, and actions. We need to look at UPCRP, documents, founding documents, speeches, expression of views, objectives, and actions. And we need to look at the FPLC, documents, operational documents, FPLC ideology, including the content of training dispensed to FPLC members, FPLC objectives, adopted and disseminated, operations conducted by FPLC, orders issued to FPLC units, and measures taken to prevent or repress the commission of crimes or breaches of discipline. We need to look at all of these events and to understand these events from before the UDCC until later. I believe, Mr. President, the time is set for...
Mr. Bougon, it's not about 1 minute. You can just find convenient moment for you to
I think it is a convenient, because I will look at the evidence related to UPC, UPCRP, and FPLC in the next part of my presentation. I think I have about 15 minutes on this topic, and a second speaker will take over from me at that time.
All right, so we will break now. Okay, fine. But I have one additional question. You provided with arguments of the defense that this Mandro video was not made for propaganda. According defense, was there then any other purpose of making this video?
Absolutely, Mr. President. All armies in the world make videos and produce what is called a diary. It's normal practice. You always make videos of all important events, and you make a diary. I contributed to the diary of the army of my country, and that's absolutely normal to make such videos. This is for the posterité of the armed movement.
Clear answer, thank you. So we will break now, and we take our regular break for 90 minutes, which means that we will reconvene at 2:30.
All rise. We will be